So today's session is going to be on overview of children's rights in Malaysia. So basically this topic covers the laws that are applicable for protection of children and how does divorce actually affect children in both real and real life, and how also a family lawyer can help a child in a family dispute, and also what a commoner like us can we do to protect a child's right. So to begin with, a child is defined as a human being below the age of 18 years old. So basically, those who are from the age of 1 up to 17, they are considered a child. And as for a child, we have got five main rights. So basically, those rights are right to health, right to education, family life, play and recreation, and adequate standard of living to be protected from all abuse and harm. So now for the first part of this session is what are the laws that are applicable for protection of children. So basically these are the acts that govern protection for children. So firstly, we have Child Act 2001. This Child Act 2001 is actually for those children who are in need of care and protection. So if you look at this slide, if you refer to section 17 subsection 2, is actually the interpretation of a child where they are in need of care and protection. So this section 17 subsection 1 clause A up to K covers this meaning of a child who needs care and protection. And moving on for custody and medical, in which this is actually temporary, is under section 18 subsection 1 up to subsection 8. For production before court for children, when custody of child and all these issues, so it is governed under section 19 subsection 1 up to 19 subsection 3 clause B. And also we have child in need of medical treatment, medical examination and treatment under section 20 and 21. 25 is for medical examination where the child has to be produced in court within 24 hours after completion of any examination or discharge. So this one is like when the child has been abused or being raped or something like that. And for duty of family member is under section 28 for physical or emotionally injured as a result of being ill-treated, like here, similar, any abuse or harm. Okay, and now they say that you can also inform to SWO. SWO here refers to Science and Wellness Organization. You have this in Malaysia. And childcare provider is under section 29. For power of court for children is under section 30. So this power of court basically is for what are the rights or what are the power of court for these kids who are in need of help and protection. So section 30 subsection 12 is if the court, just give me a moment, is not satisfied that a child brought before it under section 19 or subsection 25 that we saw earlier, that they need care and protection, they shall order the child to be returned to the care and custody of his parent and guardian. While for section 30, subsection 13 is for a court where children made on the application must have a protector and or a person who is in charge of a place of safety or who shall be the guardian or parent of the child. So if they don't have a guardian or they are not protected by anyone, so this subsection 13 can be used. So if the court for children is satisfied that it is in the best interest of a child to do so, or upon proving that the circumstances of which the order was made, so this you can relate to 13. While 33 is actually the offense to leave a child without a reasonable supervision. And then we also have the Married Women and Children Maintenance Act 1950. So this Married Women and Children Act is where the court, Sessions Court or High Court, they can make an order for maintenance of wife and children. So under section 3 subsection 1, right, if any person, this person here usually refers to husbands, where he neglect or refuse to maintain his wife or legitimate child of his which he is unable to maintain, a court upon proof may order such person to make a monthly allowance for the maintenance of his wife or such child, in which the court should see it's reasonable or not. And if a person neglects or refuses to maintain an illegitimate child of which he is unable to maintain, a court again, due to proof thereof, may order such person to make monthly allowance. So it applies to both legitimate and illegitimate child. There's no difference. And such allowance should be payable from the date of such neglect or refusal, or in fact from such later date as specified in the order. But we have to take note that if the child here, they are minor, below 18 years, and are under the care of the mother, their right is subject to the mother's awareness as to the right of her being the wife. So in this case, if there is no issue of divorce or separation, and it only arises because the husband or father had failed to prove or provide the wife and children maintenance, then yes, the court has all the rights to do so under this section 3, subsection 1 till 3. And as for the Law Reform Marriage and Divorce Act, I think we are all very used to this act. So this act governs for all these divorce or legal separation. So when the couple are in the midst of a divorce and it involves child custody, so we will have to rely on section 87 up to section 101 of this act. Now, if you see here, there's a scenario where parents had filed for single divorce petition, a unilateral petition, and the children are still minor. And for the divorce, the mother had cited adultery as the cause of the breakdown for the marriage, while the father cited unreasonable behavior of the mother. Okay, and the father had actually left the matrimonial home 2 years ago, leaving the children with the mother. But after filing the divorce, now the boy informs the mother that he wants to stay with the father and girls want to stay with the mother. Now, the issue here is what are the rights of the children, or does the parents' rights actually override the children's right? And is it fair to separate the siblings? So basically, when it comes to issue of child custody in court, the court will actually look at two circumstances. The first one is the court will actually look at the wish of the parent. For instance, like physically, emotionally, and financially, who is more capable to take care of the child. So if it's all better with the father, then by all means, the custody shall go to the father. However, it does not mean that the parents' rights override the children's right. In certain circumstances, we have where the court will also take into consideration of the child's wish only if the child is in a position to give independent opinion. Plus, if let's say the child has been very comfortable living with the mother all this while, and suddenly there is a change of environment in which, for example, the father has to move to overseas, for instance, so that's going to be difficult for the child to actually adjust to his or her living. So that could be difficult, and this could be one of the reasons why where the custody of the child couldn't be given to the father. So there are few things that the court has to look into, but it does not necessarily mean that the child custody will always go to the mother. It used to be like that, but now it's a little bit more flexible than how the law used to be previously. So it all depends on how the court look at it. And moving on, we have the Guardianship of Infants Act 1961. So this is where the child is taken care of a guardian. So the guardian have certain obligations or duties to perform, in which we have section 3 that relate the duties of guardian of the person, where the guardian will have to be responsible for all the support, health, education, the 5 rights that I mentioned earlier. The guardian will have to be fully responsible, and failure to do so, the guardian can be in big trouble. So we have section 4. Section 4 is where guardian of the property of an infant, like if let's say the child has a property, and until the child attains age of majority, the guardian will be having full responsibility over the property. And section 5, on the other hand, is equality of parents' rights in relation to guardianship and upbringing of an infant, or in the administration of any property belonging or held in trust for an infant. Now, these sections, right, they basically apply for legitimate child. So how about illegitimate child? So when it comes to illegitimate child, right, the federal court in the case of Sean O. Casey Patterson in 2001, it was ultimately decided that the Guardianship of Infants Act applies to illegitimate children also, and the court held as follows. we conclude that the wordings of Section 1, subsection 3, clause A of the Guardianship Act is sufficient to imply that this act applies to an illegitimate child. So by following the decision in this federal court case, the highest court of Malaysia has actually set path for the biological father of an illegitimate child to have equal parental rights over an illegitimate child within the meaning of Section 5 of this act. And if there is no divorce proceeding pending in court and there is no issue of child custody, the application can be made under Section 5 that I mentioned earlier of the same Act and Section 3 of the Married Women and Children Maintenance Act previously. This is Adoption Act 1952. So Adoption Act 1952 is only applicable for non-Muslims, where Section 2 is again the interpretation of a child, and Section 4 is on the restriction of making adoption orders. Section 5 is for the consents to adopt. So basically, if there is anyone who wishes to adopt a child, they have to fulfill certain requirements and they have to make an application first under this act. So the basic requirements are as follows, where firstly, they will have to obtain the consent of a biological parent. And if they have both parents, they have to get consent from both. And applicant have to understand the nature of this adoption, like what are they actually up to and whether they can commit themselves. And the applicant and child both have to be residing in Peninsular Malaysia, and the child has to be in the care of the applicant for at least 3 consecutive months before this application can be said aloud. And for basic requirements under the Registration of Adoption Act, so firstly, attendance of biological parent before the registrar to express his or her consent. And if the applicant is the mother or father of the child, there would be no requirement for any age gap between the applicant and the child. And now if the circumstances is where if the applicant is the brother or sister, uncle or aunt, he or she needs to be at least 21 years old. And if the applicant happen to be not a relative of the child, they have no relationship, he or she must have attained age of 25 years old and there must be an age gap of 18 years old between the applicant and the child. Also again, the applicant or child must reside in Peninsular Malaysia and the child must not be subjected to this Adoption Act. And consent from the biological parent is required for any adoption application, may be waived if either one of them or both the parent is deemed dead. Okay, moving on, we also have the Legitimacy Act 1961. So this act, we have two main sections that we use for child protection and their rights. So we have section 4, in which it's the legitimation by subsequent marriage of parents. So subject to section 3, the child may become legitimate if the biological father marries the mother of the child and legitimize the child by the subsequent marriage. And section 5, we have the declaration of legitimacy of legitimated parents, where there is a declaration order that has to be obtained from the High Court of Malaya for such legitimizing effect. So if a child who has been legitimized, they can always enjoy all the legal status as being a legitimate child in Malaysia. And then we also have the Birth and Death Registration Act 1957. So this act is where we have section 8. It's in regarding the information of birth that has to be given within 14 days of the date that the child was born. And section 13 is the provisions as to the father of illegitimate children or child. And section 13A subsection 1 is the surname of child. So these are all the main points that we have under this act. And we also have Education Act for the kid. So section 29A Education Act 2002 has made it compulsory where every child who has reached the age of 6 in January of the current year, which is in 2002 back then, must be enrolled in school and receive formal primary school education. So this section was actually made compulsory for all parents, and if you fail to obliged to it, you can be fined to 5,000 or a jail for a period of not exceeding 6 months or both that can be imposed for those parents who actually fail to abide to this act. Similarly, we also have this Education Act 1966. So this Education Act 1966 was amended in 2002 to provide for compulsory primary education. So it stipulated that every parent is obliged to enroll their child upon attaining the age of 6 in primary school, shall actually make the child to have compulsory education from the age of 6 onwards. And since education is actually made compulsory by law, the current policy in Malaysia still requires these students to pay certain amount of fees upon enrollment in primary school for additional books and curricular activities. And now the law has changed slightly a little. Although there is still a minimal payment imposed, financial assistance is provided by various government agencies to needy children to ensure their rights to education. So this right to education is very important for all children and they shouldn't be deprived from it. Moving on, we also have evidence of Child Witness Act. So this evidence of Child Witness Act 2007 has been promulgated to create more child-friendly methods, such as evidence through video conferencing for child victims and child witnesses in criminal cases. So, for instance, like if the child was actually abused or raped, so the child would actually be in a very bad situation, or per se that the child is not able to actually produce statements, to give statements because of the situation the child is in. So they can use these friendly methods to actually get the statement from the child and also to protect the dignity of the child as well. So this act is for the establishment of witness support service, which aims to reduce fright and trauma to children who are to be witness in any court proceedings. And we also have this Care Centres Act. So this Care Centres Act, we have Section 10. So this Section 10 is where any care center which provides care for 4 or more persons over a continuous period of time, not more than 3 hours per day, or at least 3 days per week, whether for reward or otherwise, they are required to be registered under Act 506. And Section 11 is a certificate of registration. To operate such care center is granted on the basis of the number of residents, which must not exceed the stipulated available space and the specified ratio between caregivers and residents. So this Care Centres Act is for those, we have the child care center and all this in Malaysia. So they have to be governed under this act and they will have to be abiding to all the sections provided in this act. And if they don't, okay, they can be liable to a fine not exceeding 10,000 or imprisonment for a term not exceeding 2 years or both. Now coming to the second part of this session, how does divorce actually affect children in both real or real life? So now when we see in movies, right, the kids, they will be actually very happy, very positive, very calm whenever the mother or the father, either one, the parents say that, okay, this weekend you'll be putting up at your mom's place, so pack your clothes. So the child will be actually very happy and the child will be very understanding, like they can adjust to their timing and their living environment. But this is not the same in real life, because in real life, basically the child would be in a very bad situation where the child would be emotionally unstable. They will be in a very bad dilemma where they are most of the time being helpless because they are not at the age where they can express their emotions and their feelings clearly. So it's quite difficult to actually read them. And if you don't help these kids, right, they can actually slip into depression. And these days, depression is not a joke. What more when it comes to kids below the age of 17? So we will have to be careful when we are handling with children in regards to divorce, especially when it comes to matter where they have to choose whether to live with the mother or father since the parents are undergoing a divorce. So it is going to be tricky and hard to tackle, but I think we can overcome this in the next topic where I'll be sharing with you guys how a family lawyer or a commoner can help these kids to not lose trust in life and in parents or even in adults. And they can actually be able to have counseling sessions, or they can also receive immediate support in order to prevent from being in such bad position, like they don't have to go through dilemma or depression. So now here, how can a family lawyer help a child in a family dispute? So basically, a family lawyer is like a friend in need in most cases, where this family lawyer plays a pivotal role. This lawyer would actually be the one aiding and helping those parents and the children in regards to their divorce and separation. So basically, when it comes to child custody, right, and how to help this child in a family dispute, a family lawyer can arrange to meet the child, but first of all, the family lawyer has to get the consent of the parents. If the child is below the age of 17 and is in between of the age of 5 to 17, and the lawyer doesn't necessarily need to be informal. They can be just dressed casually, and we can meet in a place where it's comfortable for the child. So we don't really scare the child off. Like the child will be actually feeling better with us around, since we are strangers to them. And we also have to observe their character for the first 15 minutes, for the first 10 to 15 minutes, right? We don't just immediately start the conversation of this divorce or the separation of the parents. We will have to like get to know the child, what are the interests of the child like, and we can also like talk about other things and distract them, and then slowly start a friendly conversation with the child. So this topic, especially separation of parents for the children, right, it can be very sensitive. So in order for us to actually bring this topic up to them, it can be very difficult and tricky, but we will still have to do it. When we are doing it, we will have to actually go slow with the child. We have to give them time to think and to share their thoughts with us, their feelings, and we have to like always listen to them. So most of the time you will have to let them speak, let them talk, let them say what they want to do. However, at the same time, we do not share our opinions, or we don't give them ideas like, okay, your parents are going to separate, so you will have to choose. No, we don't do it that way. It's just step by step. Slowly put that topic up to the child, and then we listen to what they feel, and then only get to the end of the topic, in which like we have to tell them that, okay, your parents are going through this divorce, so you will have to adjust your living as such, where you will have to spend most of your time with your mom, and probably the weekends with your dad, something like that. And you also have to take into consideration of the child's welfare, emotionally, physically, and financially. And we also have to note how is the child's relationship with the client. For instance, right, we may be acting for the mother, and the child might not be very close with the mother, since the mother is a working mom and all that. So most of the time, the child must have been spending more time with the father, and financially, the mother may be stronger than the father. So when it comes to this kind of issue, right, so we will have to take into consideration, and when we are putting this to the court later on, we will have to lay down accordingly, like, okay, these are the strengths of my client, and these are the weakness of my client. You have to do both. You have to be transparent in court later on for the child's right to be protected. And before we end with the child's meeting, we most of the time, I think this was what told by the speaker during the webinar. So she said that we can leave the child with some words of wisdom, and bribe them with some sweet stuff, so that they don't feel overwhelmed with what we just told them. All right. So now coming to the end, which is how can we do to protect a child's right? Sorry, what can we do to protect a child's right? So we here refer to the commoner or lay people. Like when you see someone who is in trouble out there, and the child is helpless, if you want to help that child, you cannot just barge into that area and then you go and help the child. No, you cannot do that. So if you really insist on helping a child, and in order for the child's right to be protected, for example, you see a child being abused and you want to help the child, but you do not know how. So here are a few hotlines or helplines that you can contact with, and you can actually let them know that such things are happening around my housing area or anywhere that you have seen that incident. So you can just lodge a complaint or inform them about this incident, and they might take some action against it. So you have this Protect and Save the Children Association, Shelter Home for Children, Malaysia Child Resource Institute, and also Talianon. And I think that is all for this overview of child's right in Malaysia.
Okay, thanks, Kanaga. Okay, there is one question.
All right.
Okay, when a lawyer meets with a child, does he or she need to meet with a child therapist, psychiatrist for a more effective session?
Yes, I mean, this is not compulsory, but it would be better because before you actually go to a divorce proceeding, they will actually make you go for mediation until if until at the mediation stage your dispute cannot be settled and you still have to go to court in order to get an order. Then yes, you will have to go through this in order for you to get an effective opinion or answer to your.
Okay, any more questions?
Oh yeah, and before I actually say thank you, I just want to apologize if there is any shortcomings in this session today.
Okay, if there is no more question, then we will end the sharing session. So thanks, Kanaga, for the sharing.
All right, thank you.